Steve Sen, counsel for the appellant David Caraballo. And Your Honor, I would like to reserve 5 minutes for rebuttal, if I may.
Thank you, sir.
Several issues on the appeal. I'd like to focus on 2 issues this morning. First, the evidence resulting in the conviction itself. Whether Mr. Caraballo's right to defend himself with his pocket knife after he was attacked late at night on the streets of Tampa by a much larger man was within the scope of his right to self-defense. And then secondly, I will move to the issue of the sentencing error that we also raised up here. Beginning with the challenges to the conviction, there were really only 3 witnesses to the events, or really only 2 witnesses to the events leading up to the altercation and then to the early stages of the altercation. It was the victim's mother and the defendant. Both of those witnesses testified that it was the victim, Mr. Harvey, who called David Caraballo over. That the mother testified that they had been talking.
Yeah, I don't think there's any issue that certainly the victim was the aggressor or the instigator. Of course, you know, in these cases and the facts of this case, we have to look at the totality of what happened. And it appears that although the victim was the aggressor, the tables turned. And the defendant then became the pursuer of a man who was fleeing, who fell sitting on the ground in a defensive posture, saying, you know, whatever he said, don't do it to me, and then got stabbed. And you have, in your brief, done an excellent job to call into question whether or not there was a stabbing or a punching at that moment in time, or whether the lethal cuts happened earlier in the middle of the fray.
Those are the issues. When you have a situation that it clearly starts out where use of force and self-defense is permissible, and then at some point for the conviction to be upheld, the state would have to prove either by clear and convincing evidence, a stand your ground hearing, or by proof beyond a reasonable doubt at trial, that the threat had sufficiently dissipated that no reasonable person would continue to use deadly force, but continue to use deadly force to kill the person.
But it was a jury issue to analyze the facts and make the call, which they did. And they found that your client turned the tables and became the aggressor and was no longer defending himself.
We're raising the issue under 2 contexts. As an initial, and in both, we're raising it as sufficiency of the evidence, and whether even if the trial court obviously accepted the testimony of Mr. Hasty, the dog walker, understandably at the sentencing hearing, and it seems pretty clear that the jury accepted that testimony as well. And then in denying the motion for judgment of acquittal, the court again referenced the testimony of Mr. Hasty as being credible evidence. We're not challenging that here. We're not saying that the jury was within its role in accepting Mr. Hasty's testimony. What we were arguing is that both at the stand your ground hearing and at the trial, his testimony, even if credited, is not sufficient to meet the state's burden.
Well, I'm sorry, Mr. Sen. What about the fact that at trial, the medical examiner gave some pretty critical testimony about the placement and circumstances surrounding the infliction of the wounds? And the jury also heard that, and it was certainly the subject of some closing argument. So even if and you've done, as Chief Judge Morris said, a fabulous job of educating us about what exactly the discrepancies between Hasty's testimony and the other facts are. But ultimately, you've got Hasty, you've got the mom, you've got the medical examiner, and you've got a jury. And the state had to prove beyond a reasonable doubt. So where do we fit into all that?
Well, I think where you fit in is at 2 stages. We're asking you to make an analysis twice. First, at the stand your ground hearing following the Bowie case, where this court made, I think, the level of review that is called for here at that level, clear convincing evidence that the lethal blows were not inflicted within the legitimate scope, because we've got a temporal time period here, and in which, as Judge Morris noted, we started off where lethal force self-defense is permissible, at some point it becomes impermissible. And after that point, did Mr. Caraballo stab the victim to death, either because it's questionable as to whether it was a stabbing. We have, and we filed a notice of supplemental authority on Mr. Hasty's testimony, which is very like the testimony, credible, but not good enough
Well,
in the
we
White
read-
case, or the Demiala case.
I read the Demiala case, and while I understand that there are some, at least theoretical parallels, I would submit to you that the facts surrounding what the little boy saw and how that testimony was presented are markedly different than what we have here. So I appreciate that, but I think it's a stretch to try to cabin this case into the parameters of the ruling.
If I may, in both cases, the witness testified that what they perceived with their senses, and then the conclusion they made based on that perception. And the court found in the prior case that when your brain is filling in a gap that may not necessarily be with clear and convincing evidence proven by what the senses perceive or beyond reasonable doubt.
But we know he was stabbed. The question is, when was he stabbed? And I guess that's the issue you're raising for.
He was stabbed 12 times, according to the coroner. And according to the coroner, 5 of those were potentially fatal. So were those fatal wounds that Mr. Caraballo admitted to inflicting within the scope of the self-defense privilege, or were they later when he should no longer have used them? And we have 2 arguments as to why they weren't.
But the medical examiner testified that the stab wounds to his back could not reasonably have been made while he was facing him in the earlier part of the altercation. And that they would have to occur in a different posture, such as when Mr. Hasty said what he said and what he saw. So, I mean, we have that evidence in addition to everything else. I mean, that's.
I mean, the medical examiner testified that the number 5 wound was to his back and was lethal.
That's correct, but is it sufficiently clear on this record that occurred, that those stab wounds occurred later on? We know that there was kind of a confused, befuddled melee in which my client was hit multiple times in the head, briefly lost conscience, came back up, and they were wrestling, struggling. He was able to get his knife out. They're rolling around on the ground.
But the medical
and he
examiner
testified that he stabbed him during that time period.
The medical examiner also told us that among the wounds that couldn't have been inflicted while they were wrestling on the ground was the number 5 wound.
But she couldn't testify that those therefore would have been later on in the time period after Mr. Harvey was no longer presenting any threat to Mr. Caraballo.
And
It's just
couldn't the
not.
jury rely to fill those gaps on the testimony of Mr. Hasty? I know you have issues with some of the accuracy and gap filling, but couldn't the jury rely on that as well as the story as the mom told it?
Well, that's the real problem with Mr. Hasty's testimony, and to a lesser extent, the mother's testimony, is he missed most of the relevant events that are relevant to the defense, that are relevant to Mr. Caraballo's testimony as to when he was stabbing. The mother's testimony was, frankly, limited as far as any details, other than her son called him over, and then the next thing she knows, they're rolling around on the ground and she's screaming, and then she realized and started trying to get somebody to call 911. And so it's just not clear from her testimony. And we know that Mr. Hasty was walking his dog and did not get to the events, because otherwise these puzzle pieces just do not fit together at all. The only way that they fit together is Mr. Hasty arrived at some point after the original melee, rolling around on the ground. That confused time period in which Mr. Caraballo testified is when he was stabbing Mr. Harvey. And is there either clear and convincing evidence sufficient to overcome that, or evidence beyond a reasonable doubt sufficient to overcome Mr. Caraballo's testimony? I'm not sure how the coroner can say that it was at this stage based on everything. And in fact, I don't know that she tried to say that at this stage. She simply said that when they're on the ground and he's on his back, you can't stab the
Let's
person
look
on the
at
back.
the totality of this, right? We've kind of been through it. And anybody witnessing, any person who's going to be witnessing a circumstance as this was, you're going to have chaotic recollections. It's, this isn't like standing in line at the grocery store and seeing whether somebody got a Snickers. People are excited, and and I think that is the totality of the circumstances. We have these witnesses, we have the forensic analysis. And my ultimate question to you is, why isn't this case controlled by Hernandez?
Well, the standard that we would ask this court to apply in initial matter is what you did in Bowie. There was certainly confused testimony there. There was certainly, and there you had the same issue we have here, which it doesn't happen very often. The specific issue here is it started off as self-defense with the right to self-defense. At some point that went away, and the state has the burden of disproving the defense. In the Bowie case, you have all the confusion like we have here, but the court engaged in fairly searching scrutiny and talked about what clear and convincing evidence means. It says that what clear and convincing evidence requires is reasonable certainty by the witness, lack of speculation, and all the points that we submit are presented here. And ultimately, it wasn't upon. I mean, if we were going back before the amendment to the law, then I would not be able to make these arguments. But the burden of proof is fairly substantial on the state's case since the amendment, and since that amendment, this court and other courts have been fairly rigorous in holding the prosecution to its defense. And in cases where that defense has not been met, the court has said, that's just not good enough. State, you have the burden of proof. And for these reasons, it's either not clear and convincing evidence or it's not proved beyond a reasonable doubt. This case and the other cases we cited in our brief, the court has held the state to its burden of proof. And that was a major shift in the state's burden that the legislature brought about. And we have seen the court being fairly scrupulous, and applying that scrupulous standard here is what we're asking the court to do.
Can I shift gears on you to another issue?
Yes, sir.
The statement, when he's sitting on the ground, hands up, don't do it to me. You have argued that was testimonial in nature. And Davis versus Washington, of course, is kind of the lead case on this type of thing. This does not appear to fit anywhere near inside Davis versus Washington. This was not a statement made to police or anything else. It was clearly an excited utterance. And
I'm not going to try to talk you out of that position,
Okay.
Judge.
Okay.
That was a dual argument. Also, we made the contention that it was just under the same heading that it was unduly prejudicial, considering the nature of what the jury was asked to interpret that out-of-court statement as being, and that's to the extent that that issue is presented, we ask that it be considered based on that standard. If I may move briefly to the sentencing issue. This is another point where this court has been fairly scrupulous in holding trial judges to a two-part procedural process, and has reversed trial courts when they do not go through that process where a motion for downward departure is made. This is another one. We filed two supplemental authorities in the last week, one of them on this issue, where this court once again said, yes, we do have jurisdiction to consider denials of downward departures, and when the trial court does not follow this two-part process that we have said must be followed, then it is necessary to reverse and remand for resentence.
Forgive me, I'm not entirely clear on which part, or if it's both parts of the two-part process that you are arguing the trial court failed to follow.
And we're at 14 and a half minutes, so just so you know.
Frankly, both. As to the different issues, he did find, I think, on the record that the victim was the aggressor, So that satisfies the one part as to that one factor. And as to the mental health basis for downward departure, the court did not seem to make a finding, but on this, but basically
Well,
made the statement
and
that,
lots of people in prison have illnesses.
correct,
That
which is
generally
suggesting that this basis for downward departure is not one I'm very impressed by. I don't care what the legislature said. And that's the kind of not following what the statutory
step
text
one-
requires.
Some of the cases that we have issued are where a judge says, I can't depart, or there's not enough here for me to depart. In this case, you have the judge specifically saying, let me just say I am not going to downward depart after discussing the facts of the case, and then even goes further and talks more about it. So it seems to me, as I read the transcript, that the judge understood he could depart and that there was evidence that might support it, but he was choosing not to, and then he explained why.
And you're at 16 minutes.
Okay, I think that's a generous reading based upon the standard, the two-part standard that this court has and other courts that through several strong court PCA opinions we've cited, opinions of this court that look to the record, look to whether the two-part thing has been followed. The court needs to find there is or is not a basis for downward departure, and then if there is a basis, whether downward departure should be warranted. With respect to the Your Honor's reading of the transcript, I don't believe it checks those boxes to find A, whether there's a basis, and B, whether downward departure is appropriate. I'll reserve whatever I have left.
Okay, you have about 3 minutes
Thank
left.
you.
Good morning, Your Honors. My name is William Schallard. I'm representing the state of Florida in this matter. It looks like we touched on every issue except issue 4, which was conceded. So I'll just start from the beginning. As to the stand your ground motion, I know this court and even the trial court made a determination that the victim was the initial aggressor. I think it's important to note that the only testimony about who the initial aggressor was came from the defendant. He's the only one who survived this encounter. So it's his testimony that's providing that. The mother said they were talking, everything was fine. Next thing she knows, they're on the ground rolling around. The defendant definitely had some injuries, but again, he told the detective during his interview that they squared up mano a mano. So the state contends that this wasn't a sucker punch, this wasn't an unprovoked attack.
But to Mr. Sen's point, the last round when the defendant's sitting on the ground with his hands up in a defensive position, the testimony could lead one to the conclusion that you would have to infer a stabbing from Mr. Hasty's testimony as opposed to actually that he saw a stabbing. Why don't you focus on that for us?
Yes, Your Honor. And at the JOA, I think we can't just cherry pick 1 or 2 sentences from Mr. Hasty. We have to look at everything in context. So if we're looking at page 449 of the record, there's a question and answer. The defendant punched the victim 2 or 3 times and question at some point, answer, and it was at that point that I, in one of his raised fists, I saw a knife in his hand. And at that point, I realized he wasn't punching him, he was stabbing him. Later on in the testimony, okay, and when the victim got up, where did the defendant go? The victim got up because the defendant had turned and started traveling north on Franklin Street after he must have struck him 6 to 8 times. And then later on, page 461 to 462 of the record, when the victim was on the ground in the middle of the street and the defendant was, if what I initially thought was throwing punches, they weren't punches, they were stabs. Stabs and punches, a knife in one hand, a fist in the other. So you can't just look at that initial sentence where he said, I saw him strike 2 times and then I saw a knife in his hand. Mr. Hasty obviously saw more than just those 2 initial counters. He saw the defendant continue to strike the victim on the ground after realizing he had a knife in his hand. So I think—
Can I fast forward you to the hearsay statement? Don't do it to me.
Yes, sir.
We we've read the briefs, I understand the argument. My question for you is, in your position in the briefing is, it wasn't a significant piece of evidence, it's harmless error, throw away. But if that's the case, why did the state highlight it in the closing?
Your first position is that this did not run afoul of the confrontation clause. The court made a finding that it did qualify under the excited utterance exception. I don't believe the statement is testimonial. Also, there's nothing in Florida case law that says Article 1, Section 16, Sub A provides more protection than the Sixth Amendment. So there is no difference between the federal Constitution and the Florida Constitution regarding this confrontation clause. Again, it was a statement, it was featured in opening and closing. However, that wasn't the only evidence. Without that statement, you still have the testimony of Mr. Harvey, who says that he witnessed the defendant chase the victim from wherever that initial encounter took place, chased him until he fell on the ground, and then stabbed him. There was that testimony. Again, the court pointed out the testimony from the medical examiner, who said that these stabs couldn't have been described, couldn't have happened the way that the defendant described them. And the jury also learned, and the court at the JOA knew as well, that the defendant lied about using a pen versus a knife. And then he hid the murder weapon in the bushes, but claimed to not know anything about that, but was very clear with the other details of the encounter that seemed to help him out. So while it was an important piece of evidence, it wasn't the only piece of evidence. So therefore, if there was error, which we're not saying there is, it was harmless error. So I believe, just to go on to that confrontation clause argument, I would note that a 402 relevancy or 403 more prejudicial than probative argument was not made below, and it was not made in appellant's initial brief. The first time that was raised was in the reply brief. So I would ask this court not to consider it. For those reasons, the state hasn't had an opportunity to respond to that. And the sentencing issue, the trial court gave a long reason why it was imposing the sentence that it was imposing. In my brief, I did argue that it did not appear that defendant showed by a preponderance of the evidence to meet that mental illness independent of substance abuse ground. But even as this court has recognized, even if the court chose to define incident broadly to include not only the initial encounter between defendant and the victim, but chose to include everything that happened, including the later stabbing. Again, I believe this court has seen that the court recognized that if it wanted to depart, it chose not to. So it's a step 2 Banks analysis. And given the nature of this offense, and you can see that the court gave an individualized sentencing after considering the totality of the circumstances, and the court did not abuse its discretion.
So your point is step 1 satisfied, step 2 is abuse of discretion, doesn't satisfy the standard.
That's correct, Your Honor. And if there are no further questions from this court, I will rely on my brief for the remainder of any arguments.
Thank you. Mr. Sims, 3 minutes.
2 quick points. We are not here to argue that there was any error below in finding Mr. Caravallo's testimony to be less than credible than Mr. Hasty's testimony. That we come here recognizing full well the trial judge and jury could do that. We are asking this court to consider whether the evidence the prosecution presented satisfied its burden by clear and convincing evidence, the standard ground hearing, and we made our arguments as to why they haven't, and as to whether that testimony, again, primarily Mr. Hasty, but also to a lesser extent the coroner, is sufficient beyond reasonable doubt in trial. That's where the focus should be, not on whether Mr. Caravallo should be believed, other than to the extent that his testimony is corroborated and not contradicted by anyone with the testimony of the victim's mother, and to the extent that it was corroborated that by his wounds and by the fact that the trial judge found that he had no doubt that the victim hit you first. Secondly, on the sentencing issue, just very briefly, As to whether, at step two, whether it's abuse of discretion standard to apply, that depends on whether you agree with our arguments that the trial judge simply did not. It's an abuse of discretion standard if the judge actually follows the
Did step
process,
one.
clearly follows step one, and at that point, the question, you might have an opportunity to consider abuse of discretion, but if it's not clear from the record that the court followed the two-step process, and if it's not clear from the record that the court accepted that this is a legitimate basis for downward departure under the statute, and the fact that there are lots of people in prisons with health issues, if you don't read that, if you read it as we do, as suggesting that's just not a basis that this court is going to follow, that is not an abuse of discretion standard. That is something that this court has routinely reversed and has to do so here. That is all I have. If the court has no further questions.